Hi, everyone, and welcome to our second installment in our legal series, which we've called Understanding Board Directors' Liability, What Board Members Need to Know. My name is Liz Tang. I use the pronoun she, her, and I'm the program coordinator for IntegralOrg. I will be in the background monitoring the chat and doing any tech support. But before we go into that, we will go into our land acknowledgement, if Yvonne could. Thank you. It's important to take the time to recognize that what we call Alberta is the traditional ancestral territory of many peoples presently subject to Treaty 6, 7, and 8, namely the Blackfoot Confederacy, the Kainai, Piikani, Siksika, the Cree, Dene, Saulteaux, Nakota Sioux, Stoney Nakoda, and the Tsuut'ina Nation and the Métis people of Alberta. This includes the Métis settlements and the 6 regions of the Métis Nation of Alberta within the historical Northwest Métis homeland. We make this acknowledgement as an act of reconciliation and gratitude to those whose territory we reside and work on today. I am very happy to introduce, I will spotlight her. There we go. Our very own Yvonne Chenier, the legal counsel for IntegralOrg. If you could click through the slides, please, Yvonne.
I'm trying.
Oh, and she's our moderator for today, and she'll also be giving a little note on the Freedom to Care Act. Yeah, she's a lawyer and philanthropy consultant and co-founder of IntegralOrg. Yvonne brings more than 35 years of experience helping those in philanthropic, nonprofit, and social enterprise sectors, as well as general legal counsel and as an advisor of planning, organizational, regulatory, and governance matters. She's an active member of the executive of the Charities and Nonprofit section of the Canadian Bar Association and is past chair of both the Alberta and national sections. She's named in the Canadian Legal Lexpert Directory for excellence in charity law and has been selected by her peers for inclusion in the best lawyers in Canada for her work in charities and nonprofit law. So with that, take it away, Yvonne.
Thanks, Liz. I'm going to say this is a wonderful topic that we're discussing today, and it's the liability of directors and officers of a nonprofit organization. That's a really narrow topic. We could talk about a lot of things about liability of organizations in general, and we do often at IntegralOrg have other sessions that specifically zero in on different facets of organizations and their legal needs and liabilities. But today our very narrow topic is liability of directors and officers of nonprofit organizations. And before I introduce our very special guest speaker, David, I will talk a little bit about a piece of legislation that has maybe some impact in this area that we should all be aware of if we're considering the organization that we work for or that we're directors and officers for, and what the position of a director and officer would be in that organization. And it is our very own Alberta Freedom to Care Act, which was enforced last year in Alberta. And it helps volunteers be exempt from liability for their actions as volunteers for nonprofit organizations. And in that legislation, it also exempts volunteers that are directors, officers, or trustees of a nonprofit organization. So that's why it's key. That part is key to our topic today, just to keep in the back of your mind. So what is protected? You know, the legislation is very specific. It's intended to protect liability for volunteers and remove the barriers to volunteering. So it's to help encourage everyone to volunteer, whether as plain volunteers doing day-to-day stuff or as governors of organizations, directors, and officers. And the definition does specifically refer to directors. It includes a director, officer, or trustee, someone who's not compensated for their role. So it's got to be someone who's a volunteer, not being paid. In Alberta, any director of a charity is not being paid, but potentially directors of nonprofit organizations that are not a charity could be paid. So you have to be careful about that. So it does talk about professional designations as well. And any volunteer acting in a capacity that includes a professional designation, if they're properly licensed or certified or authorized to be that kind of a professional for the activities they're doing, they're also protected from liability. So the example that's given is a professional like a lawyer or a psychologist volunteering legal or psychological services for their nonprofit organization. As long as they're licensed and registered to provide this kind of service, then they would receive the benefit of a limitation on liability. And what is not protected? Well, this is where we really need to think. It's not protected for anyone who is going to be reckless or grossly negligent. This is the usual kind of standard that people do not get protection for under many things, but certainly this case makes, or this legislation is very specific. And very important for today's topic, it does not affect the liability of the organization itself. So just because a volunteer, whether a director, officer, or trustee of your organization is not liable, it does not mean that your organization is not liable for the actions of these directors and trustees. And the Act specifically says that the organization has no right of recovery against the volunteer if the volunteer is not liable. So why do I care? Well, this piece of legislation enacted in 2021 in Alberta. It's not the same kind of legislation you find in other provinces. It changed the law as a result of this legislation. If this legislation is repealed, then the law will change again. And back to the common law, which my friend David will talk about. In other words, there's no guarantee that this legislation will stay. There's no guarantee that volunteers will enjoy the protection from liability in the future. So it behooves us to know about the law of directors and officers' liability in general. So I'm not going to take much time. I have a little slide on insurance here, talking about how important insurance is for organizations and indemnities potentially as well for directors that may be liable for certain things. But the overall topic is director's liability and what board members need to know about their liability, or what you as an organization need to know to help your board directors understand what they are responsible for. So we have David Carscallen, or David Sevalrud, and he's at Carscallen LLP, and which is a law firm in Calgary. His practice is in the corporate area. He does a lot of mergers and acquisitions and energy law. And I know he's spoken to a lot of organizations and business corporations and various other entities on this very topic about directors and officers. He helps provide independent legal advice to boards and to directors in both the for-profit and not-for-profit sector. He has served on many not-for-profit boards and for-profit boards over his career, 30 years plus now. And he is a presenter at other organizations like this. David and I have spoken to the Canadian Bar Association on this very topic a few times, and he writes articles and has taught courses in this area. He holds a business degree from U of C. He maintains his ICD designation, so it gives him a lot of qualifications to talk about this topic. So I'll turn it over to David, and there's a lot of information here. Your questions came in very good. We'll try to answer most of them as we can.
Thank you, Liz, and thank you, Yvonne. I need more time because I speak slowly. So I am going to try to get through this as quickly as I can. I want to make sure we understand. I want to talk about the fundamental duties of a director, and those are the fiduciary duty and the duty of care. There are lots of lists and publications that list. I mean, I saw one of about 25 duties of directors, and it's not incorrect to sort of suggest that, but all of those 25 fit as sub-duties, I guess, or parts of the fiduciary duty or the duty of care. Once we've sort of canvassed that, we'll talk about the liability that directors can have, and then how to perhaps manage that risk. So we'll start with some general observations. In my practice, I've sat on close to 35 different boards, both for-profit, not-for-profit, public companies, private companies, national nonprofits, provincial nonprofits, and local nonprofits. And I can say this sort of short list is what I commonly see. There's a general lack of awareness of what duties and liabilities directors have. It was clear at one time that being a volunteer was not a defense. There's perhaps an argument here in Alberta that the Freedom to Care Act will give you some bit of a defense, but we'll talk about that a bit more. Understanding conflicts of interest and personal agendas or outside agendas. Growing scrutiny and expectations. A large example of that is Hockey Canada. And then poorly maintained corporate memory, which can be very important if directors are sued and they can't come up with the records that support the reasonableness of the decisions that they made in the past. So the fundamental duties, as I said, were the fiduciary duty and the duty of care. There are two sort of sources of those. One is a statutory standard. The other is the common law standard. If the legislation under which you are incorporated is silent, then the common law standards apply. So there are three statutes that generally apply to not-for-profits in Alberta, and I'm not going to talk about sort of specific organizations that have been created under an act of parliament. I'm not like a university or I'm also not going to talk about trusts. This applies to organizations incorporated under the Societies Act, Part 9 of the Companies Act here in Alberta. Those are the two Alberta legislation, two Alberta acts that allow us to create not-for-profits in Alberta. And federally, it's the Canada Not-for-Profit Corporations Act. The Federal Act has a statutory version of the fiduciary duty, and the Societies Act and the Companies Act are silent, so the common law duty applies. It's the same with the duty of care. I've got reference. This is an old slide that it should be corrected. The Canada Corporations Act doesn't apply anymore. So the fiduciary duty here is what's under the federal legislation. It's similar to what's under all sort of modern corporate legislation, for-profit or not-for-profit. And it just says that every director and officer of a corporation in exercising their powers and discharging their duties shall act honestly and in good faith with a view to the best interests of the corporation. That just means they've got to put their self-interest or anybody else's interest second to the corporation's interests. The common law fiduciary duty is founded on the special relationship of trust and confidence in the integrity and fidelity of a director. I'll just indicate that there is no real difference between the common law duty, fiduciary duty, and the and the statutory duty. With the duty of care, there is a difference, and we can maybe talk about that. The fiduciary duty is owed only to the corporation, not to the members or other stakeholders of the organization. Common law duty, however, is a little broader than that. It's not limited to just the organization itself. So while you make a decision with that's in the best interests of the organization, you do have to consider how that how other stakeholders are affected by that decision. And it's a good idea to show that you have considered those interests. Good record of that is your minutes. So with the fiduciary duty, there's a requirement of confidentiality. So what the board discusses is confidential unless the board permits it to be disclosed. Everything that the board does and decides is confidential, and a breach of confidentiality is a breach of duty. In not-for-profits, I've listened to directors talk about a lot of detail about what went on in a board meeting, thinking that that was okay to share with members when they were looking for support for a particular stand. That's not appropriate, and frankly, a director that breaches that confidentiality should resign, and if they don't, they should be asked for a resignation. Conflicts of interest are another area that aren't understood very well. At common law, a director can't benefit from his or her position. And so if a director is providing some services for either directly or through another entity, consulting business, for example, that they may have, they need to get approval from not just the board, but also the members. And if they don't, then they leave themselves open to challenging the validity of the agreement they have with the organization to provide those services. And they may have to repay profits from that. Pretty strict common law rule. Some statutes do enable the payment of remuneration to directors for services and even sometimes acting as directors, but not as charities. The Not-for-Profit Act and the Companies Act in Alberta contain some rules for enabling the payment of remuneration to directors. The Societies Act is silent about that. I like to put provisions in societies' bylaws that deal with conflicts of interest. And I also like to do that in Company Act articles. And I use what's in the Not-for-Profit Act as a bit of a blueprint for those provisions. I think they really do help guide directors in dealing with conflicts of interest. Where that arises often is that directors feel like they're there to do a political job representing either their interests or some subset of the organization.
We're good.
And that causes a bit of an issue. Because their job, once they're sitting at the table as a board member, is the best interest of the organization, not the organization they may have come from. And another point, I guess, is that once board decisions are made, those decisions are the decision of the full board. And it's very inappropriate for any director to suggest they don't support that decision, because at law they do. The duty of care says that every director and officer of a corporation, in exercising their powers and discharging their duties, shall exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. That is the provision in the Federal Act, and it's an objective standard. So it doesn't matter what kind of skill, experience, or education you may have, you're going to be judged against the standard of a reasonably prudent person, whatever that is. The common law duty is described in the case that established that as conduct that may be reasonably expected from a person of such knowledge and experience as the identified director. And that's a subjective standard. That applies to companies in Alberta or corporate non-for-profit entities in Alberta that are either Part 9 companies or societies. That's a subjective standard. So if, for example, you're a lawyer with some experience in the corporate world, the standard would be higher than if you were a nurse, for example. You'd be expected to have a different level of care. There are cases where people have been held to a fairly high standard, and there are cases where someone who has sat as a director did not have any related experience to the issue that was the subject of a lawsuit, and they were exonerated because of this standard. Frankly, I like it, although there's a lot of push for a change in Alberta to have new legislation that might make the standard the same as what we have for the federal organizations. So for the duty of care, there are two defenses, and one is generally described as the due diligence defense, and the other is the business judgment rule. Both of these defenses are process dependent. So it doesn't matter what the decision is. What a court will look at is the process you use to come to that decision. If it was reasonable, even if it was wrong or turned out to be a bad result, if your process was good, you will not have liability. If your process was poor and not documented, you risk having liability. So liability for directors of not-for-profits is the same as it is for for-profit corporations. And most of that liability comes from a breach of duty or a breach of statute. A duty here is broadly defined to include both the duty of care and the fiduciary duty. In the for-profit world, all of the modern statutes have what are called unanimous shareholder agreements that allow the shareholders of a corporation to restrict the duties of directors. When they do that, the shareholders assume the liability of the directors. With the Not-for-Profit Act, the Federal Not-for-Profit Act, they've introduced the concept of a unanimous members agreement, which kind of does the same thing. It allows members to restrict the scope of directors' authority And when they do that, they assume the responsibility and liability of the directors for that. It's a little different when we're talking about the Societies Act and the Companies Act, because there is no such thing as a unanimous members agreement. There is some judicial authority that I'm aware of, both in BC and in Quebec, where if your bylaws say that it is the board that has the authority to manage the business and affairs of the corporation, then the members are not permitted to fetter the discretion of the board. In other words, the members can't make decisions that the board is supposed to make. If they don't like what the board is doing, they have to replace the board. They can't make those decisions for the board. Some try to impose that through the bylaws. Quebec has a situation or a case where they've suggested that bylaws can be treated like a contract between the corporation and the members. That's a bit controversial. It may be that to some extent that's enforceable, but it may also be a fetter on the discretion of the board, and that members are not going to be able to enforce bylaw provisions that go too far. I know there are a lot of directors and members of not-for-profits that don't understand that. Just a comment on the Freedom to Care Act, because some people believe that it does protect directors. I just point out that in the Act, it expressly says that it may include directors. It doesn't say it will include directors. And it only applies if the volunteer is acting within the scope of their responsibilities. With directors, I think their responsibilities might arguably include the duty of care, the fiduciary duty, and any statutory duties or liabilities that are expressed in any legislation, whether it's Alberta or federal. That's not very clear in that Freedom to Care Act. So I think there'll be some, over time, there'll be some changes and some clarity. In the meantime, I would not want to recommend to anybody that as a director, you tried to hide behind the Freedom to Care Act. At the same time, if you get sued, I think you'd certainly want to walk this act out and try to protect yourself with it. I think there's an important point to understand in that directors can delegate their authority to officers and volunteers, but they remain liable and responsible for that authority that's delegated. So they need to make sure that it's done appropriately and to people who are qualified. And if they don't, and they don't follow up on it, they can be that can be a breach of duty. In the Not-for-Profit Act, the Federal Act expressly describes a due diligence defense for a director in Section 149. So you have a defense where you've exercised the care, diligence, and skill of a reasonable person, including good faith reliance on financial statements or a report of a public accountant, or the report of a professionally qualified person like a lawyer or an engineer or a doctor. It depends on what the issue is that you're addressing. So the use of experts in arriving at decisions is a very important part of your due diligence defense. Section 50 of the same act says that you will have exercised a reasonable amount of diligence if you've acted in good faith reliance on a report of a professionally qualified person. There isn't any definition of professionally qualified, but I don't think there's a lot of doubt about what that is. Specific legislation like the Income Tax Act provides liability for unpaid wages up to 6 months, remitting source deductions from wages that are paid by an organization, and also GST. There are also some specific potential legislative obligations under the criminal statutes. In Alberta, there's a Charitable Fundraising Act, and that affects a lot of not-for-profits in Alberta. There's rules on solicitation, rules for the use of money, and a lot of rules related to licensing. And I've found a number of organizations contacted me in the last year or two because there's been a different group of people interpreting what they're qualified to be able to do. And there appears to be a fair amount of discretion being exercised by our bureaucrats, and changing the rules a little bit from what they were understood to be before. There are specific penalties under the Companies Act in Alberta. Every director, manager, secretary, or other officer of a company or extra-provincial company who knowingly and willfully authorizes or permits any act, default, or refusal in respect of which the company is by this act declared to be guilty of an offense is also guilty of an offense. So if you knowingly or willfully permit the organization to do something that it should not have been doing, that gives you personal liability. So protecting directors, again, there's no material difference between for-profits and not-for-profits. And Yvonne mentioned some of the common ways. Indemnities. Indemnities are pretty common in your articles or your bylaws. You can also enter into contractual indemnities, and large organizations that I've had the privilege of providing advice to, we have both contractual indemnities as well as indemnities and bylaws. And the contractual ones go somewhat farther, tend to go a bit farther in terms of what's indemnified. Insurance, Yvonne also mentioned that. D&O insurance is an interesting thing. It doesn't cover everything, and it can change from time to time in terms of what's covered or what's available. Once you've got insurance in place, it doesn't change. And once you've got it in place, it's a good idea to keep it in place. But you will probably find that you need to be a fairly large organization in order to afford D&O insurance. But it is often worth exploring the costs and what is covered with a qualified insurance agent. Source deductions and GST are two common problems. Organizations and directors directors have personal liability. And if the organization doesn't pay and ends up being unable to pay, the CRA has and will pursue directors. A practice that I have made common in respect of boards that I sit on and also boards that I advise is some form of written evidence that the organization is in compliance with its obligation to remit source deductions and GST. In some cases, that's just a letter from the CEO or the executive director or the CFO. Other cases, it's a certificate. Some organizations, it's a statutory declaration sworn before a commissioner for oaths or notary. I don't know that that's enough in and of itself. I think I also suggest that the audit committee or finance committee from time to time actually examine what it is that the financial officer or executive director examines when they complete the statutory declaration or certificate, so that they're comfortable that that those people are actually doing what they're supposed to do or what's reasonable to do in order to give us that comfort. And I think if you do that, you go a long way to what would be a due diligence defense if there was a claim made by CRA. There are smaller organizations that don't do that because the board feels they have enough information and they're closer to the bank accounts themselves, but it's something to pay attention to. Good records. So your due diligence defense and your business judgment will require a record of the process, what was considered, and any expert advice that went into making decisions. And the most important record of that is your minutes. It can also include the meeting materials. So I have come to a practice of, for organizations that I work with closely and boards that I sit on, we maintain a board, what I call a board portal, where we keep the minutes that have been approved. We also keep all of the meeting materials that were used in that, and I keep those separate from each other. The minutes are required to be part of your minute book. The minute materials, the meeting materials are not, but I think they're an really important part of the record to show what you have considered, what kind of advice you've included in arriving at your decision, and over time, what kind of deliberations you've had. Most organizations don't do that very well. Office 365 has an ability to create confidential records so that only the board can have access to them and can update them. But it does take somebody to pay attention to that. Protecting directors generally, I think having job descriptions for the board, for everybody, not just staff, but committee chairs and terms of reference for your committees. So everybody knows what the scope of their authority is and what has been properly delegated by the board. Board orientation and education is very important. And so maintaining corporate memory records, when I join a board, if it's new, I like to see the last 2 or 3 years minutes and meeting materials. I like to see the bylaws. I like to see indemnities. I like to see a strategic plan. I like to see a business plan and budgets, and not just the current ones. I like to go back a year or two. And so if there's a board portal that has those easily accessed, it's really helpful for new board members. And then a governance committee. I think if you're an organization of any size, you want to have a governance committee that's reviewing governance practices over time and working to improve them. It's not a one and done kind of thing. There isn't a rule book that says this is what constitutes good governance practices for your organization, because every organization is a little different. Governance practices need to be adapted to the culture of your organization and the needs of your organization. I'm going to end here with just one sort of example of what best interests of an organization are, and how the business judgment rule got interpreted by the courts. Just to find the description that I want to use. So in this case, this is an Ontario case, and it was an organization that owned a low-income housing project. And the issue was membership in the organization. They were a charity, and a majority of the members of the charity were residents of the accommodation provided by the charity. So the members were actually receiving a subsidized housing benefit from the charity. And good on the directors and management for getting a professional opinion done about whether that membership was appropriate. The report said, no, it's not, and that if you don't change that membership qualification, you're at risk of losing your charitable status. They didn't get the members to approve the change to the bylaws and membership because the members didn't want to lose their ability to be members. So the society went to court and asked the courts to help them change the bylaws regarding membership. And that application was challenged by one of the residents. The court agreed with the board. The board said that what it was doing was in the best interests of the charity at the time, and best interests were to maintain its charitable status. And so the interests of the organization were paramount to the interests of even the members at the time, or the residents of the organization, of the housing organization. And that's all I have. Love to take some questions if there are some.
Yeah, so we, as a nonprofit ourselves at IntegralOrg, we do know that every organization's needs can be complex and sometimes pretty specific. And it's the case with every training that we do receive questions that do need a little bit more context before we can give a fulsome answer, especially in the area of legal compliance. And so in those cases, if your question was pretty specific or we didn't get to your exact question today, we do recommend that you contact our administrator to set up a short conversation or a free 1-hour problem solving session called a clinic. And that just occurs between you and whoever you'd like at your organization and one of our experts, usually Yvonne. And you can chat to one of our experts with the questions about anything governance, bylaws. Yeah. And we'll go to the next slide, which is just our disclaimer as part of our liability interests, I suppose. And our question period is meant to be general information. So let's see if I can add Yvonne as a spotlight here. And let's go for some questions.
I just want to say thank you, David, because you've highlighted a lot of things. There's so much to cover in this area, but I always take away 3 things that as organizations we should be aware of. First of all, what statute are we incorporated under? Because that does govern a lot of what you have said. And unfortunately, not all of us are incorporated under the more modern Canada Not-for-Profit Corporations Act, where a lot of this is codified in the Act. And it behooves us to know where we are governed and what the documents are that govern us. And secondly, you did highlight insurance, and a lot of the questions that did come in beforehand talk about insurance or ask about insurance. And there's a huge difference between the insurance that the organization needs to have to operate on a day-to-day basis, which we're not talking about today, but whether or not you need directors and officers insurance, whether you can afford it, is really best discussed with a proper insurance broker that understands the nonprofit sector. It's something that people do have, and sometimes directors won't sit on a board without having that insurance in place. And another thing that's more dear to my heart is the whole process, the due diligence, record, have minutes, make a record available, because the only way corporations can operate is through the documents and the decisions they make. So how do you prove that? Through your documentation. So I know those are the highlights of what I always take away from these kinds of presentations that you make on this area, David. And it's very important that some of the questions that came in from the registrants beforehand talk about those questions as well. We do have some questions coming in the chat. They're talking about, one of them is a society is suspended. So what does that mean? Does that mean they're no longer, they don't live anymore? They're dead under our legislation potentially? Those are very specific questions to each organization. And when you say suspended, we don't know what that means. That could be, are they suspended from being a charity, or have they been revoked from the register under the Societies Act? Each of those has different legal ramifications. So you're asking about internal issues. I don't understand how something could be suspended for internal issues unless the whole board is resigned potentially. So those are the kind of one-off questions that we need more information about. But until some other questions come in, a question came in about having director's liability insurance for specific building projects, for example. And there's an example of something that relates to what the organization is doing, not what the directors are doing as directors. You have to sort of think about what your organization needs for insurance, and then specifically, what do your directors need to protect them? Insurance, due diligence information, as David was saying about the statutory liabilities. Are we paying our bills? Are we paying our remittances? Things like that. Guidelines, there's lots of good questions coming in about guidelines, and David covered things like minutes and keeping corporate records.
We did have one question from the chat. It was, do directors have liability for actions taken by members which impact the organization?
That's a question. David, you talked a lot about members, and again, probably depends on the legislation that the organization is incorporated under, but do you have any specific comments on that?
Sure, there's two. One is that if there's actions that are taken by a member which have been properly delegated by the board, that's one thing. If the member is acting outside of any authority they have, if they've done something that wasn't authorized by the directors, then I don't think the directors need to be worried about liability to the organization or themselves, but they might have to defend themselves if the member thought they were acting on behalf of the organization. If the member has been acting as a volunteer and has been delegated some authority, then yeah, the organization can have liability. If it was inappropriate delegation or inappropriate supervision or follow-up, then the directors may have some liability there. They would have to be negligent in what they've done. Not an easy thing for anyone to establish against directors personally. and there's very little litigation that I'm aware of that would suggest that directors need to be overly worried about this. But I think it is very important to be clear in terms of what's delegated and who has authority to do what, if that's helpful in answering that question.
I think it is, and it goes back to your documentation and delegation of authority and who has the authority to say what or do what. So again, paper is important. Are there any other questions while
Not
you're
from the
thinking
chat
about?
box, no.
Okay.
But yeah, we can probably get to the registration questions.
I am looking at them, and they're, unless you can pick out something that's pertinent, I'm looking at that you want to talk about, David. A lot of them have to do with specific situations about buildings, which is the organizational thing. But maybe you could comment generally, David, about different kinds of things that organizations do that directors should be concerned about, like buildings, things like that. Is there any bigger, better steps they should be taking?
Yeah, if you're building or undertaking a major construction project, I think it's very important that you've got experts involved in that field who are helping you, advise you. I like the idea of independent experts. You can have experts on the board, but it certainly helps to involve independent directors. I guess there are examples here in the city of Calgary where an example of Bears Paw Golf Club went into an insolvent situation because their clubhouse costs exceeded the budget that they had originally planned for, and it was just a poorly planned project. I think there is construction insurance, and that's different from director liability insurance, but it protects directors. It's a prudent thing to do in certain circumstances. Again, you need to understand what's covered and what isn't, but there are experts in that area of insurance.
There's another general question about, are there systems that you can check who the board of directors are for an organization? And yes, public information. If you are a director of an organization, your name is on the public registry. If it's an Alberta society or company, it's on the corporate registry database in Alberta. If you're a Canada not-for-profit corporation, it's on the federal Industry Canada database. So there is places to check. It's public information and anyone can find out. Sometimes there's a fee associated with it, but for Canada, there isn't. For sure, anyone could check. So there's lots of information. One question about how to protect Canadian nonprofit organizations from any risk stemming from relationships or collaborating with international organizations. And David and I had a brief conversation about this. This is charities exercising direction and control potentially over their agent in a third world country doing work for them. An agent is an agent of the principal organization in Canada. So the liabilities would just flow right up to where the buck stops, and where does it stop? At the directors. So the same thing would apply if you were doing work in your neighborhood as doing work in a third world country. You still have the same kind of liability. And that would come under your director's liability, general liability, and any insurance you have for that. But if you are doing that any kind of risky work, you should make sure that your insurers know the kind of work you're doing.
Yvonne, there was a question about lawyers being directors and giving legal advice. And I'm not sure what your practice might be or what your advice would be, but I don't give, if I'm on a board, I don't give any legal advice. I don't mind raising an issue that I think exists, but I would want the board to have their own legal counsel giving any legal advice. I think that's a really dangerous practice.
Yeah, well, generally, are you a director or are you a lawyer? You know, one of the two decisions you make. And our own insurers, right, have a lot to say about that. So that has where it should land, what you are able to do as a insured professional, no matter what profession you are. But that's where, you know, my confusion with the Freedom to Care Act, where they specifically talk about professionals acting as volunteers. That raises another issue.
I did get one last minute question, and I think perhaps this might be the last question of our session here. But it was, what are some guidelines to determine what decisions need to have a motion in the board meeting minutes?
Good question, David. This is back to your papering thing.
Sure. I think any decision that's made by a board has to be in the minutes. It needs to be a motion made and seconded and approved. I don't think there are decisions that a board can make that aren't by motion, and they certainly should be in the minutes. In addition, if it's a material decision, there should be some background about the process that was used and the considerations that went into making that decision. And if it's really material, what experts were included. I hope that's helpful.
Yep, I think that's pretty clear. Well, yeah, I'd just like to thank everyone today for joining us. And thank you both, Yvonne and David, for your immense expertise. We are always very interested in getting a sense of what topics you'd like us to explore in the field of anything from governance to financial management, but legal compliance as well. And so I've put in our evaluation survey link in the chat, and that will also be included in the post-session email if you are watching the recording. And if your organization does at any time need any support or even more in-depth help with even something like governance bylaw reviews, you can contact us through our admin email for any organizational development projects that are customized to your organization's specific needs. So yeah, I'd just like to thank everyone for joining us, and we hope to see you all again. And if you do have any further questions, you can shoot them to me or to our admin email as well. And thank you. I hope you guys all have a great day.
Thanks, Liz.
Thanks, David.
Thanks, Yvonne.